recess this morning. 1371 is before us. We had called it up for discussion, so I guess I'll formally call it up before the committee. House Bill 1371. There's a strike all, so make sure you're looking at the one that says the 1371A at the bottom, not the as passed the House 1371. I think the penalties are different. So I'm going to recognize our drafting counsel, Mr. Samsel, if he will just go through and sort of summarize the proposed strike all, and then we will certainly discuss.
Sure. Thank you, Mr. Chairman. The differences in the strike all between the House passed version begin on line 43, adding the word involuntary to the definition of consent. Involuntary consent means consent obtained by a therapist exploiting a patient's emotional dependence, such that the consent is not the product of the patient's free will. And then adding the definition of emotional dependence in D. And if you continue on to line 82 originally just read about the penalties in the now B, so it was a felony, and line 82 was added to the bill to add a misdemeanor. Guilty of a misdemeanor and punished by imprisonment for not less than 3 months nor less than 1 year in the county jail, fined not more than $1,000 or both. And then B is upon a second or subsequent conviction for a violation of this section, a person shall be guilty of a felony, punished by imprisonment for not more than 5 years in MBOC, fined not more than $10,000 or both. And that's the differences between two.
Okay. And I'll go back and reintroduce Pastor Eubank from First Baptist Church at Petal. I apologize, we only had about 4 minutes this morning when you started your explanation of why the Southern Baptist Convention has gotten with Speaker Gunn, who proposed this bill and passed the House. If you could just briefly tell us again, in a very short way, if you don't mind, the need for the bill, the purpose of the bill, your vision for what we're trying to accomplish.
So the bill really does three very, very important things that it addresses. And unfortunately, we hate to have to address this issue, but addresses therapists. And you can see the definition there. Therapist is wide ranging and includes a multitude of groups of people. But the idea for us to understand is that when a person enters into a relationship of trust with somebody that is a person of authority, a person that has the ability to use their power to gain access to them because of their emotional state, mental state, and they manipulate and use that to gain access to that person. Again, we're talking about a therapeutic type of relationship where they can use that. Now, the other two pieces you may find in legislation too is one piece that gives churches or individuals who report a credible accusation to another church or entity or person. It gives them that opportunity to not be held civilly liable for that. Then the third piece is, and a very important piece, is it makes those that are already currently mandatory reporters of child sex abuse, if an adult reveals to them that they were abused as a child and feel like in good faith that that person is still having access to children, then they would become mandatory reporters of that information as well. So those are the three big pieces of the legislation. In a very, very short nutshell, I can certainly try to answer any questions that you may have.
Thank you. And I know you can't reveal confidential information, but the supposition, I suppose, is that this is going on, this is happening, you're trying to keep it from happening, or are you just simply trying to prevent it from happening in the future?
No, it has happened. And there, again, I mentioned this morning too, there are 14 other states who have passed bills that are similar to this. This bill is some of it fashioned after Texas passed under George Bush when he was governor, this particular bill. So yes, unfortunately, it does go on, and I could line up countless numbers of people who have experienced this, unfortunately, across our nation. Unfortunately, have experienced this type of thing, in particular in my realm, in the world of clergy sex abuse. And so we know that it's wrong morally and ethically, and certainly there are boards that can take action accordingly, but we believe that there needs to be a much stiffer penalty that would be a criminal penalty to hopefully persuade people to not do these kinds of acts.
And I guess one question I've been asked by others that I've spoken with over the past few days is, does the church itself not regulate this activity and behavior within the church? Why should the state inject itself into the realm of the church to try and mess with the affairs going on.
Great question. Very fair question. And I would say the same would be true in child sex abuse issues as well. Unfortunately, these people use religion as a guise, and because a church is a very high trust environment, sometimes that is taken and used advantage of in the church. But of course, this is far reaching because it also involves counselors and nurses and doctors. So there are other people that it reaches into. But in the church world, certainly I understand that concern, but we believe because they manipulate and they use religion as a cover, as a sex abuse survivor, mine used that as a cover. It's religion to have access to me and to my family. And the church never knew what he was doing until way after it was long ago done. So I think that's really the reason why, is because of how good they are at what they do, that most of the time the church has no clue what's happening until it's too late.
Great. And I will just say for the record, the speaker is the author of this bill. He was invited. I know he's very busy on deadline days, so, but he was extended an invitation to come and speak on the bill if he would like to have, and I'm sure he's tied up with other situations in the House. But that being said, we'll open to the committee for questions, if anyone has them. Yes, Senator Hill.
I'm trying to remember what was said this morning, and I'm looking on lines 114 to 121, where it talks about a person under 18 years old, that it would be a crime for these therapists to be involved, which that's very understandable. But didn't we talk about this morning about consensual sex between two adults?
Yes.
And that is also in this bill?
Yeah, I think the language dealing with with minors is already law, current law.
Yeah,
That's
they're just add therapists to the list of.
right.
So where is the new section that talks about adults?
I think 77 through 81.
So even if it's a former patient and they're no longer a patient, we're going to criminalize them for having a relationship with somebody? Huh?
Yeah, if you'd like to address that, Brother Eubank.
So for 12 months, reason why that's been there, that's a very standard, not an unusual standard to have. The reason is if the person, for example, decide a relationship's over today, and then they can do tomorrow, they can start a relationship the very next day. Certainly is that they would carry over their relationship from that counselor. They still convey and has a persuasion and so based on where they just been prior, how many times they did counsel. It's a very great question. For sure, we believe that there is the idea that they can carry that over and that doesn't stop because they stop one day and start the next.
Definitions on line 40 for the 12 months.
All right. Senator Hill, did you have other questions or did that wrap it up?
One more.
Sure.
With the mandatory reporter, is that only for children? Potential sex between adults?
No, it is only for mandatory reporters for children.
Yeah,
This is
right.
for adults. Dealing with use as a child. Report that because what happens is most cases, most adults don't reveal 10 to 15 years after consent to children. And so they become an adult, they reveal that. The concern is that person still have access to children. So what that information not to not be reported makes it where that person is in that situation.
Gotcha. All right. Other questions? Senator Barnett?
Yes. So my question is, if these are adults and consenting adults, who's to say that one of the parties agreed to this, but happened to be caught? And one of the knowledge of this bill now says that I'm a victim of this because of this, but until that point, they were all together. But now that I've got caught, I wanna seem like, it's not my fault at all. So how is this going to be? So this one person can take it and basically use it as a weapon for another person if they're caught with it. And my other question is, Senator, when the chairman asked this question a minute ago, why is it that now that we are trying to bring church and state back together? It's always been this thing. of church and state. Question is, and so I'm asking that. Why are we doing all of these things, or why this attempt now made for the adults who are consenting to do this? See so many things happen amongst clergy and other people dealing with the children who a lot of times been victim. Why now, instead of being children, were the ones who was being victimized? Why is this again talking about the consenting elders that was agreed to? But I see very little talking about how we really protect the children.
Well, great question. Good answer.
Yes.
Two very good questions. One we thought about very good. Number one, as far as the consent program, this is very important for us to understand why we define consent. Is, and again, a prosecutor would have to prove had developed motive dependency, and that they had met the categories what's listed here, and not just decided to have a consensual affair. Yes, certainly that could be a concern for anybody, whether or not any law would have. It would be that a person that we could have consent, they didn't like that position of trust, that position of authority, that position. They use that in any way that the person is in a position where they're not able to be really provide sound mind and body even. And they use that. We don't believe that person can really consent that particular action because of the position of power and authority. It's a very good question. Second question is, standing grabs that position, power and consent. Certainly our kids are greatest importance. I'm a survivor. My mom is here. She would say that's the greatest importance thing for our children. But also to take care of in particular, and I want to see the example of this. These are examples that are based on truth examples. You got a 45-year-old pastor who is counseling a 22 or 23-year-old lady. Let's say she's your daughter, and he takes advantage of her and position that the authority puts in hazard for her or my daughter. He uses that, then I believe that he should be prosecuted in the sense that in poly certain state there are certain insurance broken, insurance discipline. We believe something stronger can be brought to bear. Let people know that this is not acceptable trying to become culture in our state or in our.
Any other questions, Senator Barton? Okay, Senator Sparks.
Thank you, Mr. Chairman. A couple of questions, I think, for legal to start with. Have we defined clergy anywhere else in statute before today? I'm not of the opinion to invite the government to define what clergy means. To start with. I'm not to invite government into the church to start with. As a lawyer, though, is there such a criminal proof as involuntary consent?
I've never heard of that.
Is this a creation of this bill?
I believe so.
So we don't know if that standard is, it's a criminal charge, so it's beyond a reasonable doubt. And then emotional dependency, does that exist in law elsewhere? To your knowledge?
I'm not aware of it, this thing anywhere else in the law.
Okay. Are the offenses under this law registrable offenses? Are they sex crimes?
They address that in the. No, we did not.
Okay. And I understand on a second offense within any period of time. Is there any time frame?
Yes, sir.
So for any second offense, it's a felony.
Yes.
Okay. I understand adding potentially people to the list on line 121 because we have teachers, counselors, scout leaders, etc. This is for people that are under the age of 18. I understand that part. The rest of it, as it relates to adults, is very concerning. It's also concerning to me that it's a chilling effect on young people who would be a youth pastor, a youth leader. Many people are unmarried. and serve in those roles. And they're in the same house of faith with people that they might consider as a dating person or a spouse eventually. I think most faiths, whether they admit it or not, would sort of like to marry somebody that sees spiritually like they see it. So how do we address a youth minister, a youth pastor? There's no exclusion for a 18-year-old youth leader who dates a 17-year-old member of the youth group. Am I understanding that correctly?
I don't see an exception listed in the bill.
So kissing between an 18-year-old youth group leader and a 17-year-old parishioner could potentially be subject to this bill. The reporting criteria, and don't get me wrong, there's a couple of things here. I don't think children should be abused in any form or fashion. I have a father and both maternal and paternal grandfathers who've stood in the pulpit the majority of their lives. I don't understand the need for this. I understand that the church should handle their business in the church. And if a crime is being committed, report that crime. Now, we're adding a crime that I think is going to capture some stuff we don't intend to. But my reporting question, because it's underlying language on 736, as well as around 837, the reporting situation here is a mandatory reporting that is addressing, I believe this is for more so sexual exploitation, human trafficking. I believe these are minors, or am I misunderstanding that? Is there a reporting requirement even for of age people?
The lines again, Senator Sparks?
I believe if I'm looking at the right part, it's 736, the sub paragraph 10. If I'm looking at the strike through.
Yeah.
Or strike all. Or strike through? Strike all, I'm sorry.
My understanding is, again, yeah, it's under the Department of Child Protection Services. So by definition, I think it would apply to the minors.
And is
I'm
this?
not the author of the bill. So
I understand.
Speaker Gunn is.
I
So
understand.
I'm having to read the words just like you are.
Okay, and the concern here is, and I think we've had this before with CPS, is that there are allegations. And if those allegations ultimately turn out to be unfounded, that the identity of the accuser is actually is confidential. And so in this case, we're giving the presumption of acting in good faith, and we're giving immunity for anyone who would make an allegation. Is that what those two paragraphs intend to do?
Yeah, and it's for minors.
Okay.
If you look back before line 836, it says that a minor under the age of 18 is trafficked. And that same subsection 4. And then the other code section is within the youth court.
I don't want to monopolize the time. I'm a little concerned about the intent.
And I'd like to respond, just the youth pastor, I don't know that would fit within the definition of therapist. It might fit within spiritual leader. But my understanding of 2 is it shall be unlawful for any person who's a therapist.
And that's my concern. Any spiritual leader of a church, I'd consider my youth pastor a spiritual leader. I would consider my Bible school teacher a spiritual leader. I don't know, to be honest with you, I believe everybody's a spiritual leader in the church, or ought to desire to be. So that's my concern, is we're literally bringing the criminal world, the criminal law into the church house. But I will listen to the remainder of the debate. Thank you.
We appreciate your good comments. This is certainly brand new. It's from our friends in the house, and we want to give it due consideration. Brother Eubank, would you like to respond to any of those questions or concerns expressed?
Whoops, just break that thing up again. Absolutely. Great questions. Appreciate all those questions. I'll try to remember all the ones that you raised. Number one, I would say this: I was a single youth pastor and dated somebody in a church. And here's the key question: if I'm doing things that are right and doing them above board, I don't have to worry about this law. I'm doing the right things for the right reasons. I don't have anything to worry about. I was married in the church, a young lady who happened to be my secretary's daughter at the time. And so certainly that is the case. We're talking about somebody who develops a therapeutic relationship in a counseling setting. So it's not, I'm not dating somebody. I understand that can be caught up in that potentially, but it's somebody that is using information that have to be proven in a court of law, that I manipulated the information that they shared with me because of their mental state, their emotional status, they've created emotional dependency on me, that they've done this. These laws, the consent idea, emotional dependency, these are passed in multiple other states who have these laws on the books. Not that makes it right necessarily, but I believe these are things being modeled after other states. Some Texas has had this law for over a decade. Something similar, it's not exact, but it's fairly similar. And so I agree with you. We don't certainly want the government inside the church, but the problem is that the world has come into the church and we have people that are guising and pretending to be people that they're not. And the church doesn't have any way other than saying, leave. The problem is when that happens, they go to another church and do the exact same thing to somebody else. And there has to be a way to stop them. And I believe God has ordained government in the sense to provide justice and mercy where it's needed, and provides the laws that are there to provide in the same way we do for children. And so when you speak about the youth pastor, 17-year-old, that's not allowed by law currently. That's not what this law addresses, because that child is under 18. They're under 18 under that position of power and authority, or that's already currently law. And so that wouldn't be simply addressed here, if I understand correctly, because they're same for a school teacher. If they're over that age as a youth pastor or teacher, that student's under is in school age, even though they're above 16, they're still considered, if I'm correct about that law. I think I'm not incorrect. And if I am, I certainly apologize. But I understand your concerns, but I think this has potential to have far-reaching effects that are needed, and also in the consideration of the fact that this is needed because this does happen more than what we care to admit. And we want churches, what their other problem has been too, and you've addressed the other about them sharing that information. There have been churches who know that, have contacted me. I know about this other pastor, nothing was ever done. We couldn't get a conviction. The person that was abused is scared to come forward, which is very often the case. And they just simply moved to the church. And so then that church, what do? Do they go and share that information? Or do they have to be quiet because they're afraid they're going to be sued for defamation of character? There's nothing criminal that can be done because there's no law in the books for something that happened, because there wasn't rape like what we were talking about with the ladies bill this morning. There was something that was beyond that point. So these are objections that have been raised in other states. And so I hear them, but I think the good far outweighs the difficult.
Oh, good call. All right, Senator England, question.
Yes, thank you, Mr. Chairman. And I think this is for the pastor, because I'm following you. And I think especially with your example, I mean, I understand that if you're not doing anything wrong, then you wouldn't have anything to worry about. But in your example of dating someone at church, I just want to look at lines 77 through 81 with you and just kind of go through this and do so in the light of, let's say, the father of the young lady that you were seeing at church was unhappy about you seeing her. I mean, I know that's not that far-fetched. And if we read through that portion, it says it shall be unlawful for any person who is a therapist. And again, if you look back at definitions, therapist includes clergy. Clergy does include spiritual leader. So I think a youth pastor would be included in that. So you've met that requirement. Any person is a therapist or who holds him or herself out to be a therapist, to have any sexual contact, which could be kissing. Not a lot involved there. Well, sometimes maybe some kissing is a little more involved than other, but with a patient or former patient, and you look at the definition of patient, and that means a person who received paid or unpaid mental health services, right? So then I look back up at mental health services, and I appreciate you following me as I'm doing this like an attorney is going to look at this, right? Sure. You look at mental health services, which means the treatment, assessment, or counseling of another person for a spiritual issue. Right. So that's now included. So if you're advising this young lady on a spiritual level as a youth pastor, that meets the definition of mental health services. And so now that's made that kissing, you have broken this law if that's brought forward. And I just don't, I mean, if I'm reading it wrong, let me know. But that's kind of how I'm, when I follow the definitions and the way we've lined this out, and that really just gives me concern, because I wouldn't want someone like you to be have charges like this brought, because I'm telling you, these charges, whether they're true or not, if they're brought against you, it's a career, it could be a career killing or relocating type deal. And it's going to catch up potentially a lot of good members that aren't acting in an inappropriate way. But reading through the law like that and using the definitions we look at here, that could have been caught up. And if you disagree with me, I'd like to hear why or where you think I'm maybe wrong on the definitions, but that gives me some concern.
Sure. I understand completely. And I would say too, the definition of clergy, come back to Senator's question too, clergy has been defined. We also drew those from multiple other states who define clergy in that way. It's a challenge trying to find clergy where we live in and who clergy is, because it's so wide ranging what clergy is these days. But I would say this, that again, I go back to the idea that the person is in a counseling relationship, and that could include spiritual counseling, but they've created the person in such a way, they have emotional dependence, and they have twisted or used that relationship and that information in order to gain access. And so they have done it in a wrong way. I know somebody can accuse somebody of that, and I can be accused of something any day. I can counsel somebody right now currently with no law on the books, and they can come and say this thing happened to me, and my ministry's over. So for me, when I counsel in a room that's got 18 windows and a camera that's in the far corner, because I want to be careful of what I do and what I say, because that's just the reality of what we live in. So I hear your example, but I think that the district attorney, whoever it was that would bring charges, would have to prove that that person had established that relationship of a counseling relationship and create that emotional dependency on that particular person and twisted and used that position of power and trust in order to manipulate and have gained access to that person individually.
Okay. Let me just interject here too. I'm hearing a lot of questions, and I've had private conversations with some of the members who have a lot of questions about the proposed legislation. I think it's a credit to the churches who for a long time have been the butt of a lot of jokes about things that go on in the church, both Catholic, non-Catholic, and people laugh about it, they giggle about it, but it's very serious stuff. And I credit the church for coming forward and trying to address an issue that is real, that it's serious. Having said that, I feel like given the composition of the language and the definitions before us, if we were to call this up for a vote, my strong consideration is that it would fail miserably in this committee. And I don't want to do that to well-meaning proponents of the bill, unless that's just what you would like for us to do. Of course, I can accommodate you if that's the case, but I really feel like probably a better idea would be to take the information that we've gotten so far this year to study it, and not just pretend to study it, but actually like get together during the off session, study it and see if there are things that can be done that would be beneficial to address some of the real needs here. But that's just my suggestion. It's not my bill. It's the committee's bill. So that would be my suggestion as we got to head back down. So with that being said, I would recognize a motion to lay this bill on the table. All right. All in favor, say aye. Aye. Any opposed, nay? The ayes have it. All right. Thank you. We're going to recess subject. Well, no, let's
I think we want to be today on the time.
let's just recess up to public chair. Okay, we gotta go downstairs. Oh, yeah. No. No.
Yeah, we're not done yet.
We have another one.
Yeah, that's just enjoy your conversation today and.
building is completed and ready to be, unveiled, as it were, ribbon cuts or whatever you want to call that, we just feel like that portion of the bill is a little premature. So essentially what the bill and the strike law would do is to name the DPS headquarters building, which I'm told is up and standing, and the crime lab, the crime lab, which is up and running for Representative Tom Witherspoon, Rankin County. So that's what the strike law does. I'll be happy to try to answer any questions.
I do have a question.
Yes, sir.
And we've already fought this fight once today in wildlife. The general practice has been for the Senate not to name buildings after people who are still walking around on two legs. And that is a concern that we've had and we've raised. I have no objection. We have some amazing people that deserve recognition. The question is, have we now veered from that course as a body? I realize these are all House bills that are coming over.
Yeah.
So I just, that's my concern. I'm just asking.
I had the same question.
Motion at the proper time.
Well, let me answer the question. You'll recognize you for the motion. I had the same question. The response I got was that Representative Weathersby has stage 4 colon cancer and will not be with us unless the Lord intervenes very, very much longer. So that was the response I received when I asked that very same question. All right. Any other questions? If not, Senator Wiggins, you are recognized to offer a motion.
Thank you. My motion is to table the bill.
All right, you've heard the motion. Anyone like
No
to ask?
disrespect, but for all the reasons stated and other reasons, motion to table.
All right, Senator Sparks has a question.
A question on the motion. Is it just because the people are living that they've attempted to name things after?
Well, there's that. And also I've not talked to Representative Weathersby, but as has been made apparent this session, there are many things at the crime lab that haven't either been funded or a backlog. I don't know if I'd want my name on there where things are being shot at and targeted for crime lab. So and then to the chairman's point about the premature aspect, and then yes, also seems like we always have 4 or 5 bills coming from the House to name things after people. Pretty soon we're going to run out of buildings. So I think Senator McConn's statements were very well taken.
Would you consider a reverse repealer? That's what we did on the other bills to make sure we figure out instead of tabling it.
If that's what y'all did, I would certainly consider that.
I
Thank you.
think that would be consistent.
Okay, do you want to?
I will
withdraw?
amend my,
Okay,
I will withdraw my motion.
and then you recognize for an amendment.
Amendment is a reverse repeal.
Okay. You've heard the motion for reverse appeal on this bill. Any questions for Senator Wiggins? If not, all in favor of his amendment, say aye.
Aye.
Any opposed, nay. The ayes have it. Now for a motion, Senator Wiggins.
Item sufficient to pass, strike all.
All right, you've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. All right, let's go down to, I think Senator England, Vice Chairman England has been studying House Bill 912 for us. You'll recognize, explain that one.
Thank you, Mr. Chairman, and thank you, committee. I think I can get through this one in the next 30 or 45 minutes. If y'all just bear with me. So this is the suppressor bill. Comes over from the House. It's basically identical to what was passed in Texas. If any of you guys have been following that. What you'll see on the definitions portion, obviously we've got firearm suppressor defined there, but for the purpose of this bill, a firearm suppressor is only those manufactured in this state, meaning that the basic materials are used in this state, or anything that's imported is just a generic or insignificant part. These suppressors also have to have made in Mississippi stamped on them. And if you'll look at lines 49 through 52, that's the main portion of this bill. It says a firearm suppressor that is manufactured in this state and remains in this state is not subject to federal law or federal regulation, including registration under the authority of the United States Congress to regulate the Interstate Commerce Act. That comes from litigation that's ongoing. I believe it's in the North District of Texas, and this survived a motion to dismiss. I didn't see where it was fully resolved through the North District of Texas, but I believe it's headed to the Supreme Court on that. the basic idea being that the ATF and federal agencies cannot regulate the suppressors that are made in state and contained completely within the state, left in the state under the Interstate Commerce Clause. That's why the motion to dismiss was denied in that case. If you'll look down, section 2 says that the rulemaking agencies in this state and law enforcement in this state cannot adopt a rule or a law or an order that states that these federal regulations involving suppressors cannot be adopted. They can't enforce those laws, those federal laws, as long as it's a suppressor, again, that's made within the state of Mississippi and remains in the state of Mississippi. Let's see, sections, lines 102 through the rest of that section deal with the teeth of that. It says a citizen can file a complaint with the Attorney General if there are such laws made to enforce these federal laws regarding suppressors. And then the AG may file a petition for a writ of mandamus. Again, that's all a constitutional type situation there with the Attorney General. If an entity, also under lines 92 through 101, if an entity does make a rule on this, they're not eligible to receive state funds, and they must be denied state funds if judicial action is brought and it's found that they violated that section. Section 3, again, these just go on through with section 3 involves people who are currently facing charges for suppressors. If there's not a final conviction that exists on July 1st, 2023, it's unaffected by this act. The sections 4, sections 5, and I believe section 6, those all just remove references to suppressors from those codes. Let's see. All right, I want to go down to section 8, which just states that this act goes into effect when the United States Supreme Court rules in favor of the Texas Attorney General in this Paxton et al. V. Richardson case. Again, that's the implementation of House Bill 957, which is the 2021 regular section of Texas, which this law does track. That's an explanation of the bill. It's the suppressor bill. I think we've all heard about it and all talked about it, but I am happy to answer any questions if there are any.
Senator Turner Ford.
It's by the definition of a suppressor.
Okay. We'll take a look at it.
Firearms suppressor.
Right. Right. So the suppressor goes on the end of on the end of a gun, and that's the report is the pow or the bang, I think, as we described on the floor in previous sessions when we were defining sounds of firearms. But that's the report. Right.
Good question. Other questions? Senator Suber.
Thank you, Mr. Chairman. So I'm just a little confused about this bill. I mean, I have
I'm not
suppressors
surprised.
and I love suppressors. I've hunted with them. Then there is a process and it's kind of lengthy. You have to, fill out your forms and send it in and get a tax stamp. I've seen some homemade suppressors. You can use oil filters, I've seen PVC pipe. It seems to me that anything that you can use, as long as it was in Mississippi, put made in Mississippi on it, that you could put that on the gun, it would be perfectly legal.
If it meets the definition of a firearm suppressor, then yeah, it would fall under this this code.
Why would we want to do that?
I'm sorry, what?
Why would we want to allow that?
Well, now I can say that in my hometown, I've had several veterans reach out to me that have hearing issues. And so when they go hunting, they've either had their hearing damaged or they just have issues with the report of a rifle, preventing them, maybe bringing out a PTSD type situation with them. And so they use suppressors. It's also helpful with the hearing. But again, this seems to be the trend in the country, is that suppressors for firearms made within the state and held only within the state are not subject to federal regulation. And that's what this law says for the state of Mississippi.
And like I said, I'm not against a suppressor. I mean, that's one reason I like it. If you're talking about a high-powered rifle, if you're talking about, essentially an explosion coming out of a gun, and you see, people have homemade items. I've seen them blow up. I've seen people be hurt, injured,
Mhm.
you know. I feel like it's kind of opening the door for a lot of more injuries. You know, if it's something that's made properly, I mean, I'm fine with that, but I'm just a little concerned about just the harmful consequences we could have by allowing this to go through.
Right. Now, I will say that there may be Mississippi laws regarding the manufacturer suppressor or how they're to be, you know,
I don't
manufactured.
think there's anything. I mean, it's pretty much all federal authority, you know, about the suppressor, not how it's made, you know, it has to have certain serial numbers, you know, there's certain requirements and I don't know, I don't know if I'm a big fan of this, just based on some of this language. It's like I said, I've seen too many homemade items and I mean, they're as good as, you know, some professional ones made, but you know, you saying you have a veteran, I mean, where's he gonna get a suppressor? You know, there's all kinds of do-it-yourself ways to make one. You're gonna see some of that. Somebody's gonna get hurt. And I think we're gonna have maybe some blowback on that.
Right, I understand. And I'm wondering if line 60 through 65 may address some of that, where it says a written notification to the Attorney General by a citizen residing in this state with the intent to manufacture a firearm suppressor. That allows the Attorney General to seek a declaratory judgment in the federal federal district court. So now, again, I don't think that requires them to file a report. I really think this section is probably more in lines of allowing the Attorney General to join in with the Texas opinion. But there does seem to be a written notification process there for someone wanting to, with the intent to manufacture a firearm suppressor.
I don't know. Like I said, I spend a lot of time and I, you know, spend a lot of money, you know, get suppressors the legal way, and it's not hard. I mean, it's just a little bit of a waiting period. I just don't see necessary need for it. I mean, it's, you know, like I said, they're not difficult to get, but you're doing background checks too. And I think that's a big part of it is, you know, if you have something on your record or something that shows up that throws a red flag, I mean, they're going to deny your application.
Right.
Well, that's not necessarily a bad thing.
Well, and of course, that goes back to the gun. You know, the suppressor is not going to hurt you unless somebody throws it at you really hard, right? So we're not dealing with that. And I mean, you can do things in your house that can also hurt you. You know, you can drink bleach and that's going to hurt you as well. So we're not foolproofing a law that's, you know, we're not taking out all, you know, we're not here to, I guess, foolproof everything, but there are suppressors being made in the state, you know, that are, I'm sure, professional grade, made in this state, and to be left in this state, there's ongoing litigation that says the federal government cannot regulate that, because they're trying to do that under interstate commerce clause. And of course, these suppressors aren't firearms, so they don't have the authority to regulate under that either. So this is just bringing us into what Texas is doing, and inconsistent with the law that they're working through the system right now. So I think this is a good bill that we could pass. And again, if we need to come back and change, it doesn't go into effect until the Supreme Court hears the case, and we know how long that could take.
Well,
If we need to.
That's kind of why I wonder why we're going to move forward with something that will take effect. You know, it could be 6 months, could be 10 years. I mean, who knows?
Well, and I would say that based on case law, if we have one district in the United States that has said this is okay, or that says that the federal government cannot regulate based on, you know, under the interstate commerce clause or any other federal purview that they may have, then I think that would be law of the land until it's taken up by the Supreme Court and passed on. So really, this may be in effect already if that's what that court has held. As long as you're not.
Mr. Chairman.
Thank you.
Yeah.
All right, so Tom.
Thank you, Mr. Chairman. Similar to Senator Sewer, you know, my family and I spent a lot of time shooting and shoot clays, rifles.
We know.
All that. However, in this bill gives me some considerable pause. First is the idea that we're trying to circumvent the ATS enforcement of suppressor regulations, which are federal. And seems to me one of the concerns is just firearm safety. The idea that suppressor manufacturers, those suppressors get registered with ATF. I don't see anything in here that's a stopgap for ensuring that suppressors that we offer to Mississippians under this law wouldn't be subject to any kind of standard or quality of manufacturer that seems to me it's designed to allow someone to own a suppressor that they made in their back, which I think would be very unsafe, not something I would like my kids. The other concern I have with the bill, as it's been presented, is this idea that because Texas does it, that it's good for Mississippi. That argument is lost on me altogether. The final part that.
Was that a question?
Yeah, and this was something that Service touched on as well. You're waiting on a ruling from the Supreme Court in this particular case, and that they ruled in favor of Texas Attorney General. I've read a number of Supreme Court decisions in my life, and I find very rarely are the court of learned justices rule so clearly in favor of one party or another. They typically avoid such clarity in one's decision. So I don't know how you could ever truly say that this provision would ever happen. I appreciate the effort. However, I would have a motion from second.
All right, well, if I may, I think he was recognized for a question, and I think there was a question there at the very beginning before the statements were made. I think so. So what the courts have said, you mentioned whether we're removing this from federal code, we're removing these regulations of the federal government. What this court has found is that the federal government has no jurisdiction or does not have the ability under the Constitution to enforce or even make those regulations for suppressors. They're not firearms and they're not subject to the interstate commerce clause. So that was the judicial holding on it. And I imagine even some people in Texas weren't happy with that, but that's what the judge looked at when he looked at the law, was that this is not, these aren't in interstate commerce. They're not subject to federal government regulations under that. And it's also, it's not a firearm. So the ATF was regulating these and they just didn't have the authority to do so under the Constitution. And I'm a believer in the Constitution, even the Supreme Court sometimes isn't.
That's on the appeal.
The Northern District ruled it is expected to go forward to a Supreme Court decision. Yes. Now I will remind that this body has previously written and adopted laws that with the understanding that it's pending Supreme Court approval or reversal of a certain law. That does have precedent here. So we're not doing anything odd in that, even if it's Texas and we might not like Texas or whoever else. That's something we do here sometimes.
Sure. But I think what the intent of this law is trying to do, what I can do, is try to circumvent the registry for suppressors making enough. That effort and to allow a very broad definition of suppressor. Do you agree with that? The definition of suppressor here? Very broad.
Oh, it is. It's a firearm suppressor means any device designed, made, or adapted to muffle the report of a firearm.
So that could be an oil filter. Anything they patch together in a garage, stamp made in Mississippi.
I don't see where this law does not. I would have to look at counsel and see if he knows, and I don't think you're incorrect in that statement.
It's gotta, as far as an oil filter goes, it's got to be made in the state from basic materials and without the inclusion of any imported part from another state, other than a generic and insignificant part.
And of course, there's no way in the state of Mississippi that's maintained the registry of these suppressors.
Right. I'm just saying an oil filter probably comes from outside of Mississippi.
So if I would consider it, if I may, Chairman, I would consider it a friendly amendment to add our friend, the reverse repealer on this, to maybe look at that definition of firearm suppressors. I see that that's giving everyone some pause, and I think that this is a good bill that we should pass here today, but I'm willing to work with the committee if we can move it forward.
Okay, I think Senator Hill was asking to be recognized for a question.
I want to ask the vice chairman, we're hearing a lot about overriding the ATF and federal firearm laws. I don't believe that's our first rodeo, saying that we didn't care what a federal firearms law or rule said with the ATF. Am I correct, Vice Chair?
I would say that's correct. And I would also say that this ruling out of the Northern District says that the ATF doesn't have the authority to regulate
I
here.
believe the ATF and federal regulations still say that it's illegal for somebody to possess a firearm that habitually uses a controlled substance, correct?
I believe that probably is.
And I believe I
That sounds
saw some
correct.
code brought forth today that had some of the language of our medical marijuana law that basically said, even though the ATF says that you can own a firearm, we're not going to care what that says in Mississippi, that we're going to let you still own one, correct?
That's correct. That's my understanding. And of course, that's also something that could hurt someone if it's misused at home.
Especially if somebody habitually uses a controlled substance, it might be under influence operating a firearm. Is that correct?
I think that is, the answer is correct. Yes, to that
Thank
very
you,
friendly
Mr.
question.
Vice Chairman.
Thank you.
All right, did we get all the questions? Other questions for the, not the author of the bill, but certainly the shepherder.
Shepherd of the bill. Yeah, I'll shepherd the bill.
Shepherd of the bill. Shepherd.
We have not.
All right. Any other questions? Get back on topic here. All right. Did someone attempt to offer an amendment? No. Okay. Okay. Senator Hill, you're recognized for an amendment.
I would offer reverse repealer.
Okay.
I do not oppose the amendment.
All right, you've heard the amendment. Any questions on the amendment? All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. All right, for a motion, Senator Hoover.
Motion is title sufficient do pass as amended.
All right. Strike.
Strike all, which would be to make the strike all.
All
at this
right,
point.
you've heard the motion. All in favor, say aye.
Aye.
Any opposed, nay. If there's in doubt, let's have a show of hands. If you are in favor of the motion made by the vice chairman, please raise your hand and keep it up so we can. 1, 2, 5. If you are opposed, please raise your hand. 1, 2, 3, 4, 5. It's tied, so I'm going to vote in the affirmative. So the bill passes. All right. Good debate, and I do really appreciate you all because I know we don't get the easiest bills in here, but I think that's why they're sitting here, because they know y'all are bright people and will ferret out all these issues before they get to the floor, right? So congrats on your success, ferreting these things out. All right, let's go to House Bill number 400. This one, I want to commend our esteemed counsel. He has gone through, and you should have in your stack. Hopefully, if not, let us know, and Ms. Pat can get you one. A really nice breakdown of what House Bill 400 strike all as before you does. So just to go over, the strike all amendment creates a new section of law that any person who shall deny a person the right to vote for a reason that is not provided in the law shall be deemed guilty of a crime and punished by fine not exceeding $10,000 or by imprisonment of DOC not exceeding 10 years or both. It also increases the sentences and fines for a number of election crimes. And the following table that Mr. Samson was so kind to go through crime by crime, it tells you the number of the code section which embodies that crime, the caption of that so you understand what they're talking about, the current law in the third column, then what the House bill originally did in the way of increasing the penalties, and then what the strike all did in the way of increasing penalties. And I think what you'll find, again, it's up to the committee how you want to handle this, if at all, but the House bill, when looking at what they were doing, let's just take the first one, for instance, here, the bribery, having a canvasser to use unlawful means, which is the crime. The current law would say a sentence of not greater than 1 year or not greater than $500. So essentially a misdemeanor, I guess. The House version of that would be to raise that to not greater than 10 years and not greater than $10,000. So you see a large jump from the current law to the House language. And the penitentiary does make that a felony. And then the strike all is the next one. So you would see a penitentiary, so a felony of not greater than 10 years and not greater than $5,000. So we limit the fine to about half of what the House proposed. So you can go through, I don't want to read it to you word for word. You are plenty capable of perusing through there to see what the House version does, what the current law is, what the strike all amendment before you would do in each of these cases. But that's essentially what the strike all before you does. I'll give you a second to look over it. We'll try to take any questions. You didn't have any debate on it, do you like? But I think the point is not to be lost on anybody is that it does create a new crime for trying to disallow someone the right to vote when they ought to be allowed the right to vote. So there's that, and then you have all the others. All right, Senator Turner Ford. Against, I think any person that can be proven in court that has disallowed the person the right to vote. It was added by amendment, I assume, in the committee or on the floor. No. Yes. Senator Sparks.
Thank you, Mr. Chairman. Is that section 15 that we're referencing?
Yeah.
Any person, okay.
Yes, sir.
Does this bill have a reverse repealer?
Let's look and see. The strike all does not, no, sir.
Okay, I don't want to belabor, but any person who shall deny a person the right to vote for a reason not provided in law, that's pretty vague for a felony of 10 years. I would have a motion at the proper time, Mr. Chairman.
Senator Hill.
Gone to vote where poll managers don't know. Right to go back there, you know, or even if they don't tell them that they can vote around there. I agree with that.
All right. Any other questions? Now we'll recognize Senator Sparks. All right, you've heard the motion or the amendment. I guess it's an amendment to the bill. Any questions on the amendment? If not, all in favor say aye. Aye. Any opposed, nay? The ayes have it. Any other questions, amendments, thoughts? All right. If not, it's Senator Thompson for a motion. All right, there you go. You've heard the motion. All in favor say aye. Aye. Any opposed, nay? Okay. Chair believes the ayes have it. Okay. The last one I think we're going to look at today is House Bill 1315. This was a late addition, so I do apologize. I haven't had a ton of time to study this one, but I think Senator Hill, were you working on this one for us? Oh, okay, thank God. All right, we recognize you to explain
Let me get to it.
the strike all.
Hey, basically this. Why, I mean. That was the first few sections of the bill, that language, came from the House on section 1, 2, and 3. Basically, and also section 4. Talked about that same process of basically having somebody, having somebody have to upload an ID to that, and the new part comes in section 1, 2, and 3 are the ones that section 1. Section 3 talks about the age verification, any commercial entity or third party form the required age verification shall not contain identifying information. So this is just going through that same stuff that we've had. 2, 3, and section 4, shall that the provision shall not apply to any bona fide news, public interest broadcast, website video report, or anything that shall not be restricted to the right to be news gathering organization. That's just a disclaimer there that news is not affected. Somebody will access, try to, from that pornographic website. The new part comes in, where we're actually, this code section brought forth in the House bill, that basically gives them a city waiver. You know, if you're a bookstore, give them something. Our library, they have been allowed to. You could find them in the code. Section 5 does, it removes the obscenity waiver from public school libraries, and that's on 209. That's on lines 209, and that's all that section 5 does. That's all current language, except line 209, where it takes out public school libraries. It leaves in universities, museums, colleges. We just felt like with what we're seeing in the school libraries, that we don't need to leave an obscenity waiver in a public school library. So that's what we removed. We didn't do it for public libraries, we just did it for school libraries, for kids. And then section 6 basically talks about the database that
Section 6 is just brought forward,
I'm
Senator
sorry,
Hill. The
section 6
the
is brought
language
forward. I'm looking for the new.
that was
language.
added for the vendor is
Yeah.
on lines 143 through 176.
Okay, lines 143 through 176
Yes, ma'am.
in section 3 is the new language that was added. Basically, we pay for a database that is supposed to filter age appropriate material to our kids in our schools and in our library. And we've paid a lot of money for that through the years. And what we have found is that even a kid in second grade or kindergarten can get on this Magnolia database that we were paid for in our schools, in our library, in our classroom, and they can click, and they can get on some very raunchy material. We tried it, we proved it, that you can access this, and we've been paying them to direct kids to age appropriate material. And I just got this hot off the press from here. Since 2015, our state agencies that are using them have paid a grand total of $10,036,529. And that we're not getting what we paid for. So basically, this new language says you're going to do what you say you're going to do. And there is a provision in there that if you violate this, kind of like a 3-year out, you're going to get a warning the first time, you're going to get a chance to correct it. But if you violate this 3 times, you're going to lose your contract. So that's basically what this does. And council can speak to it in greater detail, but that's all it does is take this database that we're paid for right here with this peer report and say that you're actually going to do what we've been paying you to do when it comes to age appropriate material for kids.
And I will just say, hopefully you received a sort of a rough breakdown of each of the sections as Senator Hill was going over them. It was provided to me, so I just wanted to forward it on to you. It might help as you're trying to digest the bill. All right. Good explanation. Questions, Senator?
I just have an amendment at the proper time.
All right. Any questions for Senator Wiggins?
Thank you, Mr. Chairman. First of all, I'm still looking for line 209, because I don't have it in my packet. It's section 5. Oh, there it is. Yes. Okay, got it then. Thank you.
209.
So, Senator Hill, what happened to Senator Boyd? Said we passed it, I think. that
No,
was-
we didn't pass this part of it.
No, I'm asking what happened to Senator Boyd's bill.
I think it's about that. We're only wanting to use this vehicle for this data.
You said sections 3. Are you talking about Senator Boyd's bill from this year or last year? Okay. I got you. So that, okay, so that was passed.
That's the last.
I don't necessarily
If I'm
believe anything
wrong.
the House is gonna do because they've proven
I will say,
certain things.
in response to that question, I sat down with Chairman Bain, as I guess we all try to do with our counterparts. Last week, I was, informed that he intended to take that bill up and, pass the Senate bill. I honestly have not been following it with all the crazy meetings today to see if that actually happened or not, but that was what I was told by my counterpart, and I know things change, so I'm certainly not gonna hold into that, but that was the plan, discussed.
Well, the latest record was today, the House title sufficient to have passed as amended, brought it out of Jud B. So they did amend it.
Senator Boyd's bill. Okay, so, and then on the section 5 part of this, help me understand how those of us who support parental rights and those of us who support jurisdiction can, even though we may not like it, how we can justify passing something that we the government involve ourselves in. So when I raise my kids, I tell them what they can and can't look at the library.
We're
You know,
talking
and
about,
now we're removing this exemption. A library is for people to take books, and how do we know that the government is not going to take this and go beyond it and prevent To Kill a Mockingbird or to prevent that or to prevent something like that?
in all due,
Hold on. My question is, how do we justify that? Because it is a very slippery slope when we get into that in libraries.
no, it's only public school libraries that we
Again,
removed it.
So,
Public-
And we every day. I know, that's what the asterisks are
but
for.
my question is, how do we justify that? Which in a public school is elected by the people, governed by a public school board. And we're the government telling the school board and people, parents, what their kids can and can't look at.
We already tell bookstores that they can't sell pornographic materials to kids. The books that are in the school libraries, I could be arrested if I read those books outside the school. We rate movies and we tell parents that children can't attend movies, certain movies, if they're under a certain age. And all this does is remove the obscenity waiver for a public school library. It puts them on the same playing field as a bookstore that can't sell pornographic material to children, or to the theaters that you can't let underage kids in movies. This is not creating a new section of code. This is just going by the original section of code, 9729-101 through 9729-109, and takes the waiver away so that we protect our public school kids from having access to pornography.
But isn't
And-
that the parents' rights to determine what they do?
I think they put us in charge of the legislature to make policy. We send a lot of money to the public schools, and there's a big outcry from parents who are outraged at what they found in their public school
So why
library.
don't they go and elect the school boards and let them do it instead of us chilling free speech? And by the way, let me say this, pornography, the federal government and the federal US Supreme Court has defined what pornography is. My fear is the chill that goes on, that I have the government telling me what my kid can't check out of a book. That's me and telling my child. So why do I want the government doing that?
We are in the, why do we have child protective services? Okay, why do we have obscenity laws that apply outside the public schools? Let's just get rid of all of them. You want to just get rid of all of them? Let's just let them go into any movie, and let's just get rid of everything that we have that protects children. I mean, because that's,
Nope.
seems
Nobody's
like,
gonna be arrested by a child going into a 14-year-old going into a rated X movie. They're not going to be arrested. They may be gone. Those are guides, and I wouldn't even say it's censorship, it's guides.
This is not censorship. This is
But it
going
is.
by, no, it's not. It's removing the ability for obscene and age inappropriate materials to be in school libraries.
You can
That's all it
guarantee me that something like Kill a Mockingbird. is
No,
gonna be
no,
prohibited.
that the Supreme Court has made a ruling on what obscenities are, what obscene materials are. That is codified already into our law.
But you yourself have advocated for parental rights and not invading parental rights, and this seems to me to be invading parents' rights of their kids and what they can and can't see. I
Well,
want my child going into a library, checking things out, and I will tell them what they can and can't look at.
Well, when your child's on a computer at school, the parent doesn't know what they're looking at.
Well, maybe the parent should. Is that not what parental rights is about?
Well, y'all kill my parental rights bill, so you walked into that one.
No, we're either for parental rights or we're not, or we want the government to involve itself in parental rights, or we don't.
Well,
This
I had
may be a step too far in trying to have the government tell me what my children can read in a library. It goes too far.
my parental rights bill would have required transparency in curriculum and given parents access to all that they do not currently have. And this body chose not to take that up. This is a simple bill to keep children from being able to access pornography through the Magnolia database
But
in
the-
their school classrooms and in their libraries.
But the gatekeeper of that is the public school district, who is an arm of the government, correct?
We are the gatekeepers of about $2 billion that we send to the public schools. And I think we are in a position to make policy.
So in that case, the First Amendment doesn't apply.
The First Amendment does apply, but there are laws to protect children. We're not reinventing the wheel.
I just think by removing that section, we are picking and choosing what we decide is it's the heavy hand of government. If the federal government came in and told us what we can do, we'd be screaming up in arms. And I don't understand why we get involved in these parental right issues when we claim that we support parental rights. So, Mr. Chairman, I think Senator England may have an amendment, but I think it's a step too far at a certain point.
All right, Senator Goodbar has a question.
Thank you, Mr. Chairman. Senator Hill, is there a federal law already in place? That's CIPA?
There may be, but apparently our state's not following it because we're still paying Magnolia.
So there is a federal law in
I
place.
don't know. I don't know if
And-
there's a federal law, but I know we've paid $10 million to Magnolia over the past 7 years.
And so what you're saying is laws are really ineffective in this arena. Secondly, the
No,
question
because
is,
we have consequences in this bill.
So-
They'll lose their contract.
secondly, who's going to be prosecuted for a violation of this?
There's no prosecution in there. This is for the database.
Okay, so when we're taking out the public school language in line 209, what are the consequences if this were to happen?
Maybe they could be prosecuted. I don't know.
Potentially prosecute school librarian. Superintendents, principals, teachers.
We can prosecute somebody who gives pornography to a child right now. Why should we exempt somebody in the school? I'm saying, do you want to keep pornography in the schools? Do you want to keep it legal?
Okay, question, Senator Barnett, for a question.
Yes, my question is that when I look at this, I see public. But if I'm not mistaken, and if I am, I stand to be corrected. If there's a member of the committee that can shed light on that, that's fine with me, but do not the state of Mississippi also use state monies to fund charter schools?
that charter schools would be included in this. Charter
Yeah.
school is a public school.
Okay, well, when we talk about public, it doesn't say and or charter schools, it just says public schools. So if we're gonna talk about schools in the state of Mississippi, then I would like for the language to say exactly what it is, so there is no doubt about what we're talking about. If it's public schools, it's public, but it's public, charter, private, what, if it's state funded money that's gonna be used in this, then that be spelled out exactly. So
I'm sorry.
Let me just,
So,
let me,
and wait, I mean, and also I have to agree with my Republican colleagues when we talk
Let that
about,
be noted.
let that be noted. I'm sure I'm already noted for saying that and with everybody looking as well, but when does parents have, or when does parenting come into play? When are parents, we're the ones that have the kids, we're the ones that take care of the kids, we're the ones that, we spend the most of our times with our children. I don't think in a way a parent's right or a parent's ability to raise their children or to be able to advise them children should be dependent upon the law when we talk about these things, these cases. I just think we're going, and I agree, and I have to agree. Four.
may I
Senator
respond?
Hill, you
This bill has nothing to do with parenting. This bill has to do with what you can get on a computer at school for a kindergartner, a first grader, a second grader, a third grader, whether or not we think they ought to be able to access pornography and age inappropriate materials that talk about things that I'm not going to mention in this committee, whether or not we think they ought to be able to access that in a public school. If y'all think yes, vote no on the bill. If you think they shouldn't be able to access this, then
But
vote for the
I
bill.
could take, my son could take his telephone into a public school bathroom or into a public school classroom and access the same thing. So now.
That's not a state supported and state paid for device that we have
But
a
we're talking
contract
about-
with. We have a contract with these people that are supposed to be filtering this to age appropriate material and they are not doing it. If y'all are
I
okay
think
with
that's
that,
up to the school.
if
district.
y'all are okay with that, let's just take a vote and say that we're going to continue to have pornography and we're going to continue to pay these people for what they're not doing. I'm perfectly happy. It's very obvious that this bill was a setup, that, you know, we just brought this bill to the floor so that everybody could beat it to death. And that's fine. I'm good with it because I'm going to try to do the right thing regardless. Because I think it is our responsibility as adults and as legislators to keep pornography and age inappropriate material out of the hands of children and out of the eyes of children. And I'm not going to change my mind on that. But if y'all don't think that we ought to if we should keep paying the $10 million that we paid to Magnolia that are supposed to be directing age appropriate content to our kids and they're not doing that, then let's just let it go. I'm bringing this to your attention. I'm saying we're not getting what we're paying for. And we've been paying them for years and years and years, and the kids are still getting age inappropriate and pornographic material through this database. So, you know, I'm perfectly happy with whatever this committee wants to do. But I feel like attention needs to be brought to it because, you know, parents send their kids to school. Not every parent wants their kids. You might want your kids to look at pornography, but every parent doesn't want their kid to look at pornography. That's just where we are. You know, if you think your 4-year-old needs to learn about, or kindergartner needs to learn about foreplay and, you know, positions and all that stuff, then fine. But I don't want my grandkids seeing that in public school. And I'm a taxpayer just like everybody else. And there's a lot of mamas that feel the same way, that they don't want their kids to see filth when they get on a damn computer at school.
Senator DeBar, I think did you?
Yeah, I just had an amendment at
All right,
at the
you're
proper
recognized for an
time.
amendment.
Yes, I'd like to offer a reverse repealer, and if I could speak on that for just a moment.
You recognize.
Okay, I know we've been adding reverse repealers. This is something that came to us very late, and I think it's something that a lot of us have heard concerns from families at home and for parents. My kids go to school. I do think that we need to, as a state, get better about parenting. But we can't really legislate that. I've got parents in one school district that I represent that a lot of the kids go home and they have illiterate parents. And so they're all the basic education they get is that at school. And we do know, and I know we've all seen enough of it to know that some of this stuff is in schools. Now, whether this bill is proper or the best way to handle it is up for debate. And I know this came on us pretty quick, and I will say, I don't think it was brought on to us pretty quick just for the sake of beating it up. I think it was brought up for debate, which we're having, but I think that it's a debate that we can and should continue because there is material that needs to be discussed and maybe a better way to find it out. So that's why I offer reverse repealer to keep this bill being one that we can discuss, hopefully after we all get out of here and have maybe some more level heads about it. And that would be my amendment. I ask for support of that.
Senator Sparks.
Now, on the amendment, is your amendment part of the setup?
It is not.
Okay,
The amendment was-
I don't consider any bill that comes before us set up, and Senator Hill is very passionate about this item. It is something we need to look at. We also have the chair of education in the room. This bill is important and it is inappropriate. And Senator Wiggins, I don't have children yet. I hope to one day. And your children are getting older. The children today have a different experience with electronic devices that are available out there. So I appreciate your reverse repealer because I would like to continue to look at this, but I also want to be clear that we're going to take every bill serious in here. So I don't want you to feel that we've not. Thank you.
Thanks, Senator Sparks.
Okay. Anybody else questions for the amendments? Not all in favor of the amendment, say aye.
Aye.
Any opposed, nay? The ayes do have it. All right.
Speak on the bill.
Senator Wiggins, you're recognized to speak on the bill.
Thank you. I want to clarify something. If you vote against this bill, and I recognize that Senator Hill is passionate and I understand. But it is not, if you vote against this bill, that you support your kids seeing pornography. It is not. So let's make that record clear as well. What this is about the First Amendment. And what this is about parenting. And to Senator, what's your name? No, to the senator
Barnett.
to Senator Barnett, to Senator Barnett's point, sorry. The parents, you have libraries at schools to learn. Every public school library I ever know, every private library has meetings. You can go in there, you can see that. And to Senator DeBar's point, I am not in favor of prosecuting librarians, school librarians. And this is what we're doing by removing that section 5, is putting them in the crosshairs. And if you don't believe that's a step too far, then just go read the line of Supreme Court cases that talk about that. And we may not like it, and I don't like it, and the Supreme Court has ruled that child pornography is not protected by the First Amendment. But what the Supreme Court has ruled, I'll go watch People versus Larry Flynn. They ruled that that is allowed. So it's more than just that. And for people who have this feeling, you know what? Show up to the school board, show up to the library, because they're not. But maybe they are now. I think this is how this is going to go on the floor. I think the reverse repealer, I voted for it, but just know that this bill has not been vetted and it's going to be hard. And we need to think long and hard about the parents before we start putting librarians in jail and before we start contradicting ourselves about parental rights. The government cannot satisfy those things. That's all I have to say.
Senator Barnett,
Motion at the proper time.
you're not recognized for a motion yet. I think people are still speaking on the bill.
I'd like-
Senator
I'd
England.
like to-
Well, I just have a question for Senator Wiggins, if he'll respond.
Sure.
If that's
Sure.
okay. Thank you,
And
Mr.
it's
Chairman.
been a long day.
Thank you, Senator Wiggins. It has. And I just want to, you mentioned the People versus Larry Flynn as being a good example for, outlining constitutional law.
Well,
I just wanted to know if you think that would be appropriate for a 6th grade class to watch when learning about constitutional law.
No, I don't. And you know what? I tell I've told my kids, you're not going to see that. And you know what? They know they're not, if it's there, that they're going to do it, that they're not going to do it. The question is, do we want the government, i.e. the school board and us, you and them telling what my kids can and can't see. Okay, it should be me as the parent. It should be me. And for those that say, oh, well, there's parents that are not doing it. Well, why is it good in that situation, but it's not good in other situations? So there's a famous line that was said up here. We contradict ourselves all the time up here, and we're contradicting ourselves by removing that. I don't want the government telling me or my kids what they can do. I will do it. And I will not prosecute. And yes, I will say it. My mother was a librarian for 20 years. Trust her judgment on everybody. And if my mom went to jail because some parent comes in and says they showed them To Kill a Mockingbird, you bet I'd be crazy. So I think we just have to think about that.
All right, thank you for that. I would say I appreciate everyone's patience today. It's been a long deadline day. We all, I know, are trying to do our dead level best to present our points and to get those points across to everyone else. And I just want to say I appreciate you all, your patience in this committee. I know it's made for a very, very long day. I think as Senator Hill articulated, there are instances where you don't have a parents. And I agree 100,000% with what Senator Wiggins is saying. We would hope that in every house across our state that you had a parent that was as forthright and involved in his or her child's life as Senator Wiggins and his wife obviously are. And that's a blessing. And their kids have flourished and are doing very, very well. You do have situations, unfortunately, where you have guardians and wards of the state. You have children that don't have a two-parent family. You have children who don't even have a one-parent family. You have aunts, uncles, grandparents who are doing the very best they can. And I think in this instance, what the bill is attempting to get at, and maybe it's not perfect, very few bills are, is that there should be some base level protection for children when they go to our public schools that we're paying for, that if they log on to the computer, maybe outside of the parent's eyes, of the grandparent's eyes, the students, counselors, whoever, and they unfortunately get onto a site that's can be very disturbing. I think that's the point of what Senator Hill's language is trying to accomplish. I would just ask everyone to try to keep that in mind. And if there's a way of getting there between now and getting it off the floor, I would certainly work with anybody that was of a mind to do so. But again, y'all are in charge of this and we're going to take a vote and we'll do whatever you all want us to do with that. But I think Senator Sparks maybe wanted to speak. All right, so anybody else? I don't want to cut anyone off. All right, Senator Hill, you're recognized to close and then we'll vote.
First of all, obscenity is not protected speech. And To Kill a Mockingbird would not be classified as obscene. And what about the children's rights not to access pornography? If they're not even attempting to and they're clicking through that stuff, they ought to have a right to not have to see that on some of those on websites when they're clicking through a young child and they don't even know what they're getting on at school. They should be protected. So that's the only thing that I'm trying to do is protect these kids' eyes from having to see this stuff that they don't even know what they're going to see. So that's basically it.
All right. For a motion, Senator Hill. Correct. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right. Motion to rise and report. All right. Thank you all.
Take a job, Joe.
You too, man. That's impressive. I didn't know that was going to work.
Oh, I know, right? I got one built up here.
Yeah, well, that's a good question. Yeah, I go to the game tonight?
Almost.